Bacon documents deliver devastating blow to DeCastro. Michael Blue Bacon Pierattini delivered a devastating blow to claims by Jose Chille DeCastro that he doesn't have a criminal record by releasing documents for proof of DeCastro's history of arrests on Tuesday. The documents, declarations of both Pierattini and his lawyer Paul Katrinek, show an extensive criminal history dating back to the 1990s. While not all of the charges resulted in convictions, and some are still under seal, the snapshot of DeCastro's life paints a picture of a person who was out of control at an early age, with multiple protective orders issued against him for threatening behavior. While DeCastro occasionally slips and says no criminal record in this decade, even that isn't true, as there are multiple harassment prevention orders against him starting as early as 2021. We now present to you Pance's reading of Paul Katrinek's declaration, presented without alteration.
In the Superior Court of the State of California, in and for the County of Los Angeles, filed July 30, 2024. A declaration of R. Paul Katrinek in support of defendant Michael Pierattini's reply to opposition to defendant's motion for summary judgment, or in the alternative, summary adjudication. I, R. Paul Katrinek, declare as follows. I am an attorney duly licensed to practice law before all courts of the state of California. My law firm is counsel for defendant Michael Pierattini in this action. The following facts are within my personal knowledge, and if called as a witness herein, I can and will competently testify thereto. Plaintiff's counsel will not say plaintiff has no criminal and civil records in California, Nevada, Washington, Ohio, Massachusetts, Alaska, and Oregon. The plaintiff's long criminal history. I hired GG and Associates to conduct an investigation on plaintiff, wherein it was discovered that plaintiff had various criminal and civil charges against him. Plaintiff's criminal charges included harassment, obstructing and resisting a peace officer, trespassing and disorderly conduct, criminal threats, giving false information to police officer, stalking, and theft in the second degree. GG and Associates found a total of 29 criminal and civil charges against plaintiff. I personally went to the various court websites and downloaded the documents in the attached request for judicial notice. On September 25, 1993, plaintiff was charged with stalking and disorderly conduct, to which plaintiff pled guilty. On December 13, 1993, plaintiff was charged with theft in the District Court of the State of Oregon, to which plaintiff pled guilty. A bench arrest warrant was made for plaintiff's failure to appear as directed. Thereafter, plaintiff violated the conditions of probation by failing to attend theft talk class. On May 8, 1995, plaintiff was charged with giving false information to a police officer in the District Court of the State of Oregon. On April 24, 1996, plaintiff was charged with giving false information to a police officer in the District Court of the State of Oregon. On June 11, 2004, Casey Bytheway filed a request for order in the Los Angeles Superior Court against plaintiff. Casey Bytheway requested both personal conduct orders and stay-away orders against plaintiff. Casey Bytheway further requested the judge to order plaintiff to sell or turn in any guns or firearms that plaintiff has or controls. In the request, Casey Bytheway describes the 5 most recent instances of abuse she and her fiancé, Eric Allen Montoya, endured from plaintiff. First, on June 10, 2004, plaintiff threatened to go to Colombia and pay a Colombian $1,000 to come back to the U.S. to kill Casey Bytheway and Eric Allen Montoya, or to break their legs. Previously, in February of 2004, plaintiff trespassed onto Casey Bytheway's balcony and was observing Casey Bytheway and her friends in the living room. Plaintiff threw a lighter at the door to scare Casey Bytheway and her friends. Plaintiff then ran to the front door of the apartment and attempted to get Casey, by the way, to come outside. When she refused, plaintiff began yelling profanities and threatening to harm everyone when they left the apartment. Plaintiff attempted to open the balcony door to the bedroom where Eric Allen Montoya was sleeping. In January of 2004, plaintiff attempted to break into Casey, by the way's apartment by repeatedly pounding and kicking her front door. Plaintiff cracked Casey, by the way's front door in the process. Plaintiff then broke through 4 sheets of plexiglass covering Casey, by the way's apartment balcony and attempted to open the balcony door, during which plaintiff was threatening to kill both Casey, by the way, and Eric Allen Montoya and to tamper with their vehicles. Casey, by the way, sustained bruises on her hip and leg from attempting to hold her front door shut from plaintiff's kicking. Lastly, in October 2003, plaintiff broke into Casey, by the way's apartment through her balcony door. Plaintiff threw Casey, by the way, against a wall, spat on her face, and choked, hit, and kicked her. Plaintiff assaulted Eric Allen Montoya. Plaintiff was yelling profanities and threatening to kill Casey, by the way, and Eric Allen Montoya the entire time. Additionally, plaintiff destroyed Casey, by the way's personal property and kicked a hole in her bedroom door. That evening, plaintiff stayed inside Casey, by the way's parking garage waiting for Casey and Eric to come and go. On June 11, 2004, Casey, by the way, filed a domestic violence prevention action against plaintiff in the Santa Monica courthouse. On July 13, 2004, Eric Montoya filed a civil harassment action against plaintiff in the Santa Monica courthouse. On August 27, 2007, Michael Henson filed a civil harassment action and temporary restraining order against plaintiff in the Burbank courthouse. On November 14, 2007, Casey, by the way, filed yet another restraining order against plaintiff. Casey, by the way, requested personal conduct orders, stay-away orders, and for plaintiff to be taken under submission for attorney fees. On December 4, 2015, Francis Koenig filed a civil harassment prevention action and temporary restraining order against plaintiff in the Stanley Mosque courthouse. On January 3, 2018, Lawrence Weiner filed a small claims action against plaintiff and plaintiff's corporation, Ethics SCS Incorporated, in the Pasadena courthouse. On September 23, 2021, Dinah B. Chavez filed a civil harassment protection order and temporary restraining order against plaintiff in the Stanley Mosque courthouse. On August 31, 2022, in a letter to opposing counsel, the Disciplinary Council of the Supreme Court of Ohio stated that plaintiff engaged in the unauthorized practice of law by drafting what purported to be a power of attorney and instructing another person to sign it. Disciplinary Council notes multiple unsuccessful attempts to reach plaintiff. The letter further states plaintiff has an active warrant for his arrest in Lawrence County, Ohio. For these reasons, Disciplinary Council concludes that service on plaintiff will be unlikely. On October 17, 2022, Daniel Clement filed a civil harassment protection action and temporary restraining order against plaintiff in the Van Nuys Courthouse East. On January 6, 2023, Michael Pierattini filed an anti-harassment protection order with the District Court of Washington, County of Pierce. The order included the following restraints: no contact, as well as exclude and stay away. On March 15, 2023, plaintiff was arrested by the Las Vegas Metropolitan Police Department. Plaintiff approached the driver of a detained vehicle. Officer Bork, who was conducting the traffic stop, told plaintiff he can continue recording, but had to stay away from the detained driver. Plaintiff continued video recording with his cell phone and did not move. Plaintiff advised Officer Bork that he is a constitutional law scholar. Plaintiff refused to move or back away from the detained driver. Officer Bork told plaintiff that he is being detained and to go to his patrol vehicle. Plaintiff told Officer Bork not to put his hands on him. Plaintiff was being physically uncooperative, argumentative, and disobeying lawful commands while being detained. Plaintiff refused to approach the patrol vehicle after being instructed to do so various times. Plaintiff again declared himself to be a constitutional law scholar. Plaintiff refused to comply with Officer Bork's verbal commands or escort. Upon being handcuffed, plaintiff admitted that he had been arrested 4 times previously for similar crimes in various states. Plaintiff was cited and booked for refusing to give the officer reasonable space to work, refusing to obey lawful commands after being advised that he was detained, swatting Officer Bork's hand away, physically tensing up his body, physically resisting handcuffing by tensing up his arms, and being physically uncooperative with officers. On February 26, 2024, plaintiff was charged with harassment, telephone misuse, and electronic communications harassment in the District Court for Hartford County. Plaintiff's recent incarceration and production of his YouTube channel from jail. Counsel for the defendant only learned that plaintiff was allegedly incarcerated on June 28, 2024. After receiving this information, I personally reviewed his YouTube channel. He plainly had access to his email and is playing games once again. He was producing shows regularly from jail. Below is his YouTube channel, link included. It will certainly be disingenuous for plaintiff to claim ignorance of the service of documents and the inability to litigate this case prior to counsel substituting in. He produced 78 YouTube videos while in jail, which is almost 1 video a day. He had access to his computer, access to his email, and certainly the ability to litigate this matter prior to counsel substituting in. I personally looked at the video of the sentencing upon receiving notice from the counsel that he is in jail, and his conduct was outrageous. DeCastro got lucky at the district court level, and if it goes to the Court of Appeal, his conviction will be reinstated. A municipal court judge sentenced DeCastro in Nevada, and a district court judge overturned that conviction. DeCastro has called his conviction frivolous, but it is anything but. We are not addressing the incorrect claims that his conviction was frivolous in the objection. Suffice it to say that a prominent First Amendment lawyer has explained why, if the district attorney appeals, his conviction will be reinstated. See the videos linked here. Chille DeCastro's appellate quote-unquote win can be reversed. He consented to the quote-unquote illegal detention. DeCastro's transcript did not garner sympathy from the Nevada Court of Appeal, should the district attorney decide to appeal. DeCastro called the court bailiff a pig. As noted in the description, he even called the marshal a pig in front of the judge. DeCastro called the bailiff a pig, and the judge said, "What did you say?" DeCastro responded, "I said he," the bailiff, "is a pig. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Executed by me this 30th day of July, 2024, in Los Angeles, California. Signed, R. Paul Katrinak."